distinguished speakers, Professor David Linan from University of South Carolina, the United States of America. Professor Jonathan Verschuren from Tilburg University, the Netherlands. Dr. Bzhar Ahmad from Soran University, Kurdistan Region of Iraq. Dr. Nirmala Pillay from Leeds Beckett University, the United Kingdom. Mrs. Giselle Durana, attorney from the Philippines, and Ms. Julie Kusimba from Area Finergy Holdings Limited, Kenya. The Honorable Rector of Hasanuddin University, who in this occasion is represented by Director of Partnership, Dr. Mahatma Lanuru, ST M.Sc, the Honorable Dean of Law Faculty of Hasanuddin University, Professor Dr. Farida Patitingi, and Vice Deans, the Honorable Head of International Law Department, Dr. Iin Karita Sakharina, SH.MA, professors and lecturers of Law Faculty of Hasanuddin University, and all the participants. Welcome to International Webinar of Law Faculty of Hasanuddin University with theme Law in Time of COVID-19 Response, Effect, and Future Legacy. My name is Fadilla Jamila, and I will be hosting this afternoon seminar. This event is part of our 69 Dies Natalis, and as part of our celebration, we have been conducted a number of academic events during this past month. For your information, this webinar is not only accessible in Zoom meeting, but also streamed live in our YouTube channel called Fakultas Hukum Universitas Hasanuddin to be able to reach broader audience. The committees decide to pick this theme as the world currently faces this global pandemic and affect countries in many different ways. Therefore, by conducting this webinar, we hope that we could get an idea of what the countries are currently facing, what effects have been brought by this pandemic, and of course, what we could learn from it. We would like to send our highest appreciations for all our distinguished speakers for allocating their time to speak on our event. Especially we know the time difference between one country and another. It is a great honor for our faculty to have all these remarkable speakers in our event. We hope all the participants will take benefit and enjoy our today's webinar. This webinar will be divided into 2 panel sessions, and we will have 3 wonderful speakers for each session. To begin with, let us hear the report from the committee presented by Dr. Birka Latif, SH.MH, LL.M, as the head of the webinar committee. Dr. Birka Latif, SH.MH, LL.M, time is yours.
Thank you so much for the opportunity. I hope my sound is clear. The Honorable Rector of Hasanuddin University, Unhas, represented by the Unhas Partnership Director, Mr. Dr. Mahatma Lanuru, ST M.Sc, the Honorable Dean and Vice Deans of Unhas Law Faculty, the Head of International Law Department, the Honorable keynote speakers who are coming from different parts of the world. There is Professor Jonathan Verschuren from Tilburg, Professor David Linan from South Carolina, USA, Dr. Bzhar Ahmed from Soran, Iraq, Dr. Nirmala Pillay from Leeds, UK, Ms. Julie Kusimba from Nairobi, Kenya, and Ms. Giselle Durana from Manila, Philippines. Mabuhay. Ladies and gentlemen, good afternoon from Makassar, and hello. I am Birka Latif, Head of Committee for today's webinar, and also Head of Unhas Law Faculty International Cooperation and Partnership. It gives me great pleasure to speak to you this afternoon to welcome you most cordially at the official opening of the 69th Dies Natalis International Webinar Series with thematic Law in Time of COVID-19 Response, Effect, and Future Legacy. These events is part of the Unhas Law Faculty anniversary activities and a forum from practitioners, academics, researchers, and also observers of legal issues to provide views and share experience from various perspectives in fields and situations in their countries, especially when the COVID-19 pandemic occurred. Handling and recovery of the COVID-19 pandemic will certainly have an impact on our current condition and also in the future. Together, we will contribute our thoughts and inputs narrative in strengthening the condition of our country and the world community as a whole. Ladies and gentlemen, allow me to express my deepest gratitude to those who have made this international webinar possible. Many thanks go to the Rector of Unhas, Unhas Director of Cooperation, the Dean of Law Faculty Unhas, and the Head of International Department, and also all of committee for their great supports. I also like to thank to the invited speakers, Professor Jonathan Verschuren from Tilburg University, Netherlands, Professor David Linan from South Carolina University, USA, Dr. Bzhar Ahmed from Soran University Iraq, Dr. Nirmala Pillay from Leeds Beckett University, UK, Miss Julie Kusimba from Area Holding Limited, Nairobi, Kenya, and Miss Giselle Durana, lawyer from Manila, Philippines. We were present even though we were in the different time zoning, and I am personally deeply really appreciate everyone's present for today. I do hope this international webinar can be one of the ways to provide of a wider horizon to develop our new paradigms in doing our best strategies within countries, and also will help that we will can come and do another events in the future for the forums academica. Good afternoon, stay safe and healthy everyone. Thank you so much and God bless us. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi
wabarakatuh. Thank you, Dr. Birkalatif, for the remarks. Please, everyone, give an applause for Dr. Birkalatif. Next, I would like to invite the Rector of Hasanuddin University, who in this occasion is represented by Director of Partnership, Dr. Mahatma Lanuru, ST M.Sc, to deliver his opening remarks as well as to officially open our webinar today. To Dr. Mahatma Lanuru, ST M.Sc, time is yours.
Okay, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Honorable the Dean of Faculty of Law, Hasanuddin University, Honorable our these international speakers who participate in this webinar, they're all participants. Good afternoon, everybody. Thank you very much to all of you for being here today in this very interesting and engaging international webinar organized by Faculty of Law, Hasanuddin University. My name is Mahatma Lanuru. I'm a Director of Partnership of Universitas Hasanuddin. Unfortunately, our Rector, Professor Riyad Febrian Anwar, is not present in this event because she has to accompany the Ministry of Education that visit us today for opening the Science and Techno Park at Hasanuddin University. It is such great honor for me to speak on behalf of Hasanuddin University. Let me begin with giving you warm welcome to this webinar. I think it's very interesting webinar organized by the Faculty of Hasanuddin University. And also the theme that they choose in this time is very interesting. Law in time COVID-19 pandemic, response, effect, and future legacy. Before we get started, I would like to express my appreciation to the Faculty of Law, especially to the committee, because without hard work of them, we cannot make this webinar come true. So thank you for the committee, thank you for the Faculty of Law, from the Dean, Vice Dean, Head of Department, Study Program, and also all of the students that support this webinar. And I think it's Faculty of Law is very active faculty in our university. In today's webinar, we will learn several topics, very interesting topic, relate to the legal aspect of the pandemic, COVID-19 pandemic. In this webinar, we will see a snapshot of COVID-19 impact to Indonesian legal institution. And we will also listen to several experience for other countries from the Philippines, and also we will also listen Kenya's experience. Other interesting topic related to the legal aspect of the pandemic, COVID-19 also will be presented by different speaker. I saw from agenda, there is from Iraq, UK, the US, and the Netherlands in this webinar. Thank you very much for all the international invited speaker. I'm sure today we will have fun and full of learning. So I hope this event will help us better understand the legal aspect of the pandemic COVID-19, and hence we will have a better adaptation to this COVID-19 pandemic. Well, I don't want to take much time to this event because I need to hand over this to the committee to run and manage this webinar. So by saying Bismillahirrahmanirrahim, on behalf of the Rector of Hasanuddin University, I formally open the webinar and let's start the webinar. That's all for me. Thank you very much for listening. I hope you enjoy this webinar. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much for your remarks and for opening our webinar. Please give an applause for Dr. Mahatma Lanuru. Before we proceed to the next session, let us hear the kick-off presentations presented by the Head of International Law Department, Dr. Iin Karita Sakharina, with title Snapshot of COVID-19 Effects to the Indonesian Legal System. For your information, the committee believes that it is important for us to get the picture of Indonesian legal system due to the COVID-19 pandemic, so that we can compare later on with the situations in other countries that will be further discussed in the panel session. Dr. Iin Karita Sakharina, time is yours.
Thank you, MC. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Good afternoon. The Honorable Rector of Hasanuddin University, who's in this occasion is represented by Director of Partnership, Dr. Mahatma Lanuru, the Honorable Dean of Law Faculty of Hasanuddin University, Prof. Farida Patitingi, and all the Honorable Vice Deans, all the Professor of Faculty of Law, and then all the lecturers of the Faculty of Law who attends this webinar, and all the our special distinguished speaker here today is addressed to Prof. David Kalinan, Prof. Jonathan, Dr. Bzhar A, Dr. Nirmala Pillay, Ms. Giselle Durana, and Ms. Julia Kusimba. Welcome to all of you, and then thank you for being ready to attend our webinar international series. And of course, all the wonderful participants who attend this webinar this lovely afternoon. First of all, I would like to start this webinar session by delivering some of situation, condition, and policy in a frame of snapshots on COVID-19 impact to Indonesian legal institution. This kick-off session aims to provide this webinar a brief yet compact observation as to how our legal institution, public and private, have to cope up or to embrace the so-called new normal in a year after the COVID-19 being declared as a global pandemic. Hopefully, this kick-off could provide a thrilling start to this webinar session. What we mean by Indonesian legal institutions encompass public and private institutions. For public, we shall describe the COVID-19 related changes made by the courts, prison, detention facilities. While for private, our focus will be to describe how Indonesian law firms strategically adapt to the COVID-19 policies imposed by the government. This kick-off enabled to cover all the legal changes happened in Indonesia in relation to spread of COVID-19 disease. For instance, in relation to tax relief policy or the legal policy specifically aimed for labor and industrial works due to the time. So, I will start first. Since this COVID-19 attack all over the world, including our country, Indonesia, which more than a year now, the data that we have from last March 28, 2021, that mentioned Indonesia have been registered around 1.5 million COVID-19 cases, with around more than 40,000 people die from this virus. For this effort to prevent further increase of the virus, then Indonesia has been reported to successfully distribute 2.3 million doses of vaccine, with 3.78 million have been fully vaccinated or vaccinated twice. I myself already also got the vaccine as a member of the Unhas. That's why we Unhas most of Unhas Hasanuddin University member, both lecture and staff already got the vaccines. But unfortunately, this barely covers up only 1.4% of the total population. Based on its prospect in containing the virus, Law Institute ranks Indonesia COVID Performance Index at 85. When compared with other Pacific countries, Indonesia ranks significantly low, especially among Southeast nations, with Singapore at 13 rank, Malaysia at 16 rank, and even Myanmar, who currently undergo but persist at 24th rank. Significantly fallback in mitigation effort is believed due to Indonesian weak early prevention measure to mitigate the spread of the virus. When early COVID-19 responsive measure was almost non-existent due to the elite Indonesian government took an anti-science stance and believed that coronavirus stood no chance of entering the nation. For better or worse, Indonesia decentralized system also led into this concerted effort to contain the virus. Indonesia, in general, advocates for large-scale social restriction. A restriction on certain activities of being infected with a disease and contaminated in such a way as to prevent a possible spread of disease contaminated. It's according to Article 1.11 on Law Number 6, year 2018. This policy is preferred because Indonesia at least according to the government, could not afford managing outbreaks while ignoring potential economic distress coming from hard measures such as total lockdown. While Jakarta enforced wide lockdown to contain the virus, other big provinces like Makassar opted for micro lockdown or large-scale social restriction. Even then, the legal enforcement of these containments was relatively weak and inconsistent between regions. Society also experienced rampant distribution of hoaxes to instill fear or opposition against COVID-19 related measures imposed by the government. Of course, we could not cover all the policies made by the executive bodies in relation to COVID-19 management. However, few are worth noting. Like to combat hoaxes, the Indonesian government actively supervises any coronavirus-related information. Hoax spreaders will be penalized under Law Number 11, year 2008, concerning electronic information and transactions, Law Number 40, year 2008, on the elimination of racial and ethnic discrimination and act of hate speech. From time to time, central government had issued national travel restriction. On travel restriction that will be enforced in May in the coming of Idul Fitr is the ban. So the government will ban to travel during Islamic Idul Fitr holiday season. The ban, which is effective from May 6 to 17, mainly applies to civil servants, but the general public is also argued against traveling domestically. While central government committed to vaccinate over 180 million people within 15 months duration from January 2021 until April 2022. So still one more year to go till all people maybe in Indonesia can get the vaccine. What the interesting is Indonesia, perhaps being the only one who prioritized vaccine distribution to the younger population as opposed to the elderly, which notably known for being highly vulnerable to the virus. According to Indonesian Health Minister, the unorthodox decision was taken because younger generation tends to be highly mobilized and carry higher risks to transmit the virus. Government at the central and regional level were actively campaigning for mask usage. The campaign also spread in smaller regions such as villages. Back in 9 September 2020, Indonesia received global spotlight due to the policy enforced by local authority in Sama district of Gresik, Regency, to punish anyone who refused to wear masks to forcibly dig graves for victims of COVID-19. At least 3 middle-aged men and 5 minors received these sanctions on September 2020. This was done in hope to push empathy by non-maskers on struggle faced by the frontline workers. What happened into the Indonesian courts on the pandemic? The prior to the pandemic outbreaks, it is not permissible under the nation's criminal procedural code for the local courts to conduct criminal proceeding in absence of defendant physical presence. Physical presence. However, the virus potency to transmit airborne between individuals eventually met the rigid procedural practice, and any other face-to-face activities are deemed to risk to maintain. In response to such risks, the Supreme Court of Indonesia, which is Mahkamah Agung, issued the circular number 1/2020 concerning guidance to the administration of duties during the prevention period of the spread of coronavirus disease or COVID-19 for the Supreme Court and all the judiciary bodies. Simultaneously, the Supreme Court also released the regulation number 4/2002 concerning administration and trial of criminal case in court electronically. Change in court workflows. The circulars later changed the operation Indonesian court in the following ways, like shift to virtual court sessions, broaden the regulation number 4/2002 also signifies expansive definition of courtroom for Indonesian court, to which includes teleconference or any virtual session hosted by the court inclusion. As a result, the court elements such as judge or panel of judges, substitute clerks, and the prosecutor might attend the trial in the courtroom or at their own personal workings or in their own personal working space, whereas center or prison where he or she was being held. Changes made in prison and detention facility. The implementation of social distancing protocol also brought a rather controversial measure by the Ministry of Law and Human Rights to release number of convicts, at least around 37,000 inmates and more than 36,000 convicts and around 920 juveniles were released by May 2020. The measure was designated to reduce the overall inmates population in Indonesia. Those would enable the physical distancing protocol to be enforced in prison and detention facilities. The measure gained traction as soon as revealed that the release would also cover the convicted of the corruptors. Accordingly, release will be given to the corruption convict who is over 60 years old and had undergone 3 of its sentence times. And while in the strategic measure for the law firms, that's we can mention here, like from the Hukum Online has recorded the registered case in Indonesia e-court system as much as more than 295% increment compared to the last year. However, those figures do not necessarily indicate a need for law firm service during the pandemic. Indonesia law firm hence have to implement some strategic measures to maintain their competitive edge in this challenging situation and grab the opportunity from the significant increase of legal cases during the pandemic. The restriction for social movement and work from home policy has forced Indonesian law firms to adapt into new working conditions, such as law firms still have to provide first-class services for their client needs or demand through virtual means with no difference before the pandemic. Video teleconference becomes the daily routine for a lawyer to interact and coordinate to each other. They therefore have to invest in technology by providing adequate devices and software in supporting legal work. It is also must be complemented with skill upgrade of lawyer in using technology. That's the good thing, maybe. While in industry-based specializations, since many business sectors are worse hit by the pandemic, Indonesian law firms inevitably have to reconsider their specialization and identify which sector may endure or even grow in the pandemic time. Some law firms have to focus on a niche and distinctiveness of their field to face a harsher competition between law firms. In case it turns out that they are less distinctive, they have to change their business approach by tweaking their service or recruiting a new number. Law firms also have to be more realistic by applying an industry-based specialization approach to maintain their current clients or get a new client. Yeah. I think that's all my presentation for today. Thank you very much, and then happy seminar. Thank you.
Thank you very much, Dr. Iin, for the comprehensive snapshot of Indonesian legal system post-COVID-19 pandemic. Please give a round of applause for Dr. Iin Karita Sakharina. Now we are moving to the agenda we all have been waiting for, the core of our webinar. The first session will be guided by Mr. Ahmad Fachri with topic Adapting Legal Policies in Time of Pandemic. Let me read the short biography of Mr. Fachri. He served as lecturer at Private Law Department here in Law Faculty of Hasanuddin University, while also working as advocate in the capital, Jakarta. He graduated his undergrad here in Hasanuddin University and pursued his master degree in Leeds Beckett University, the United Kingdom, majoring international business law. Without further ado, let me present Mr. Ahmad Fachri. Mr. Ahmad Fachri, time is yours.
Is my voice okay?
Yes, it's clear, Mr. Ahmad Fachri.
Thank you for MC, Ms. Fadilla Jamila. Ladies and gentlemen, I would like first to thank the Honorable Hasanuddin University's Director of Partnership, Dr. Mahatma Lanuru, ST, Master of Science, on this occasion represent the Honorable Rector of Hasanuddin University. Thank you, sir, for officially opening this webinar. I would like also to thank the Honorable the Dean of the Law Faculty and the Head of International Law Department, Dr. Iin Karita Sakharina, SHMA, for kicking off this webinar with excellent presentation. My thanks also go to the committee head, Dr. Birkalatif, LL.M. My name is Ahmad Fachri Faqi, lecturer at the Law Faculty of Hasanuddin University. The committee has assigned me to be the moderator for the first panel. I want to welcome to all participants, which up to now have reached about 350 participants, but I think the number is still increasing. On behalf of the committee, we truly appreciate you for joining with us this afternoon. As MC already announced, the main theme of this webinar is law in time of COVID-19. response, effect, and the future legacy. We are now joined by 6 remarkable keynote speakers from Asia, Africa, Europe, and America. Please allow me to welcome our keynote speakers, Professor David Linan, Professor Jonathan Verschuren, Dr. Nirmala Pillay, Dr. Bzhar Ahmed Abdullah, Ms. Giselle Durana, last but not least, Ms. Julie Kusimba. As we are in a different time zone, let me welcome you from our local time. Good afternoon from the city of Makassar, Indonesia. Welcome to Hasanuddin University and our law faculty. We hope all of you are fine and great. We are truly grateful and honored for having you all in this webinar. Since the COVID-19 was declared in the last year as pandemic, governments worldwide have enacted new legislation, implemented novel policies, or taken ad hoc measures to mitigate the risks to public health or protect their society from economic distress caused by the pandemic. For this first panel, we have 3 panelists who will discuss an issue on adapting legal policies in the time of pandemic. Those speakers are Ms. Giselle Durana from Philippines, Dr. Bzhar Ahmed Abdullah from the Kurdistan Region of Iraq, and Dr. Nirmala Pillay from Leeds, United Kingdom. For your information, each speaker will have 15 minutes of presentation. And if possible, we will open the Q&A session before the ending. So we encourage all participants to ask directly to speaker or write down your question in the chat column, please. Now, I am going to commence the first panel. I call upon Ms. Giselle Durana as the first panelist. As we can see on the screen, the short bio of Ms. Giselle Durana. Ms. Durana is currently working as Attorney V in the Career Service Executive Board with over 6 years of working experience. She received a bachelor degree at St. Augustine University and obtained a master's degree in law from the University of Queensland in 2017. Without any longer, Ms. Durana, time is yours.
Hello, good afternoon, everyone. Can you hear me?
Yeah, it's clear.
So, good afternoon. Dr. Mahatma Lanuru, Dr. Iin Sakharina, Professor Bir Kalatif, our host for this afternoon, Ms. Fadilla Jamila, and our moderator, Mr. Ahmad Fachri. Good afternoon, and our esteemed speakers as well. My topic is on legal practice in the Philippines amidst the pandemic. So if you may allow me, I will now share my presentation. Can everyone see the presentation?
Yeah. Yes, Ms. Durana.
So legal practice in the Philippines is any activity in or out of the court which requires the application of law, legal procedure, knowledge, training, and experience. So unlike in other jurisdictions where there is a distinction between a solicitor and barrister, here in the Philippines, once a person passes the Philippine bar exams and becomes a lawyer, he or she can practice before the courts and even prepare pleadings. So in our list there, practice of law encompasses litigation in court, as well as in quasi-judicial bodies and administrative bodies, preparation of pleadings and other papers, providing legal advice to clients, and handling the legal affairs of a corporation. My topic this afternoon will focus on the first two examples, that is litigation and preparation of pleadings. Oops, sorry. So as an overview, here is a list of our courts and quasi-judicial or administrative bodies. So in your left side, there is a list of courts there. And the highest court in the Philippines is the Supreme Court. And there are first level courts. From the bottom, the Metropolitan Trial Courts, Municipal Trial Courts in cities, Municipal Trial Courts, and the Sharia Circuit Courts. Our second level courts include the Regional Trial Courts and the Sharia District Courts. And we also have the Court of Tax Appeals and the Sandigan Bayan, which is a court for or against public officials with that particular salary grade. On the other hand, we have quasi-judicial or administrative bodies. These are technically not courts, but they have been vested with the authority to investigate cases and to render judgment in cases which involve their mandate. So for example, our Civil Service Commission tries and hears cases involving government employees in the Philippines. Another example would be our Commission on Audit, which tries cases which involve the implementation of auditing rules and regulations in the government, and so on and so forth. We have our examples there. So here in the Philippines, particularly in the National Capital Region, we are currently under an enhanced community quarantine. With a spread of the COVID virus, this was imposed by our government as early as March 17, 2020. And the first enhanced community quarantine lasted for about 2 months. And after that, there was an easing of restrictions. However, with the latest surge of COVID cases, we returned to an enhanced community quarantine from March 29 to April 11, 2021. So that is, again, the strictest classification of quarantine. So with our quarantine here in the Philippines, there have been the legal practice has adapted to the changes brought about by limitations in mobility. So before the quarantine, for example, the filing of pleadings in courts and service of those pleadings to the opposing parties are made in person, through registered mail, and through e-filing. We already had a system for e-filing as early as 2013. However, it was not used as extensively as it is currently done now. Before the quarantine also, it is required for the parties to appear personally before the court or the quasi-judicial or administrative body. So in my case, for example, when I was still in private practice, I had to drive for 3 hours in order to go to a court and attend the hearing there. It's also common here because since the Philippines is an archipelago and there are lawyers that are based in other islands, they are with a face-to-face appearance requirement, they have to travel to the National Capital Region by plane, so perhaps 45 minutes or an hour's plane ride to the National Capital Region in order to attend the hearings there. However, since the imposition of the quarantine, there have been some innovations, and one of those is as regards filing and service of pleadings. So aside from personal service and filing through registered mail, the courts now allow filing and service through private courier, since they remain open and their services are relatively faster than that provided by the government's Philippine Postal Corporation. E-filing was also adopted, but the key change there was under the old rules or under the old guidelines for e-filing, the date of filing is the date of receipt of the hard copies. So even if you file through electronic mail, if the court does not receive the hard copy, it is still not considered filed. However, with the new rules, the date of electronic transmission is now considered the date of filing or service of the pleading. So if I send an email and it is received by the court at 4 o'clock in the afternoon today, that is considered already as duly filed and served to the opposite party. Another innovation is appearance of parties and counsel through video conferencing. This was not practiced before, but with the pandemic and with the thrust of the court to ensure that its personnel and as well as the parties are not unduly exposed to the threat of the virus, the Supreme Court issued a circular or administrative memorandum which allows the conduct of video conferencing. So with the different levels of quarantine now in the different areas of the Philippines, these courts still continue their hearings, but without physical appearance of the parties, but rather through the conduct of video conferencing. So the practice of video conferencing was adopted only on sometime in 2020, April 2020. It was pilot tested in hearings involving criminal cases, and only select courts were authorized to do so. But then it brought about a very positive result, which is, as you can see, in just over a week of pilot testing, 4,683 persons who were deprived of liberty were released. And after 2 months, 21,375 video conferencing hearings were conducted by judges. As a result, for perhaps in less than 4 months, as of October 2020, 81,000 persons deprived of liberty and children in conflict of the law were released through virtual court hearings. This is quite remarkable because in our country, the length of time within which a case can be decided prior to the pandemic was considerably long. So let's say 2 years or more. But with video conferencing, which enables the parties to appear before the courts without having to travel and to physically go to the courts, the resolution of these cases have been expedited. So with the success of the pilot testing, the use of video conference in hearings was expanded to now cover civil and criminal cases. So there is a success rate of 80%. So by January 16, 2021, the Supreme Court already issued guidelines on the conduct of video conferencing. So as of last month, March 16, 2021, all courts in the Philippines are already authorized to use video conferencing hearings. As regards the quasi-judicial and administrative bodies, they also adopted separate guidelines on either e-filing or virtual hearings. So the quasi-judicial bodies did not adopt in full the guidelines provided by the Supreme Court. So for example, in the Civil Service Commission, they allow e-filing of pleadings that are not required to be under oath. On the other hand, in the case of the Commission on Elections, they allow the filing of all kinds of pleadings through e-filing. However, there is also no provision as to video conference hearings. Other examples of quasi-judicial bodies and administrative bodies that have adopted their own guidelines on e-filing and virtual hearings are the Energy Regulatory Commission. This commission adopted both e-filing and virtual hearings. The National Labor Relations Commission, on the other hand, did not expressly provide for e-filing, but then it allowed the conduct of mandatory conciliation and mediation through video conferencing. Finally, the Professional Regulatory Commission also allowed the e-filing of pleadings that are non-initiatory. So the common concern in the Philippines as regards e-filing and virtual hearings is connectivity, because there are still far-flung areas which are not reached by the internet. So this is one concern that is yet to be addressed. But with the adoption of the guidelines on e-filing and virtual hearings, the resolution of cases before the courts and before these quasi-judicial bodies and administrative bodies have greatly been expedited. So that is all for my talk this afternoon. Thank you very much. Terima kasih.
Thank you, Ms. Giselle Durana, for your comprehensive presentation about Philippine legal system, especially for law practice during the pandemic, I noted some important point like e-filing and video teleconference become important tools in this era. Thank you again.
Thank you.
Okay. Now we proceed to the second speaker, Dr. Ahmad Bzhar Abdullah. Okay. As we can see on the screen, Mr. Ahmad is a lecturer at the Law Faculty of Soran University in the Kurdistan Region of Iraq. He received his bachelor degree at Soran University and master degree in law from Leeds Beckett University. He was awarded PhD from Soran University in 2020. Just for information, Mr. Ahmad was my classmate during my master degree back in 2014 at Leeds Beckett University. And in my opinion, he was the brightest student in the program. Mr. Ahmed, please take your time.
Thank you very much, Mr. Ahmad. I'm happy to see you again. First of all, I'd like to thank Faculty of Law at Hasanuddin University, particularly Mr. Ahmad, for inviting me to take part in this important webinar. If you allow me, I'll share my presentation.
Okay.
Okay. Hello, everyone, ladies and gentlemen. My presentation title is Response to COVID-19 through Adopting Legal Policies in the Kurdistan Region of Iraq. In today's presentation, I will be talking about 4 subjects. First, the spread of COVID-19 in Kurdistan Region of Iraq, and then response to COVID-19 at the level of legislative authority, and thirdly, response to COVID-19 at the level of executive authority. And lastly, I will talk about the legality of orders of executive authority which has been issued by the government. Okay, let's begin with the spread of COVID-19 in Kurdistan Region of Iraq. Since the emergence of COVID-19 throughout the world, the total confirmed cases in the Kurdistan region of Iraq is 129,356 cases. Just for your information, the number of population in the Kurdistan region of Iraq estimates to 6 million people. And from those cases, the total recovered cases are 112,817 cases. Among those numbers, the number of people that have been dead due to COVID-19 are 3,761. The total active cases up to yesterday was 12,778 cases. Okay, let's turn to the second part of the presentation, which is response to COVID-19 at the level of legislative authority. As you may know, that the first country that responded to COVID-19 at the level of legislative authority was the United Kingdom, which enacted the specific act for combating COVID-19. Unfortunately, in the Kurdistan region of Iraq, no law has been enacted by the legislative authority. But the only legal basis that we have in the Kurdistan region of Iraq is Article 368 and Article 369 of Iraqi Penal Code of 1969. According to Article 368, it states that anyone who willfully commits an act that spreads a dangerous disease harmful to the lives of individuals, they will be subject to imprisonment of not more than 3 years. And Article 369 states that anyone who unintentionally commits an act that spreads dangerous disease that harmful to the lives of the individuals, they will be subject to imprisonment of not more than 1 year or fine of not more than 150,000 Iraqi dinars. We have another legal basis that the government can rely on to combat COVID-19, which is Article 3, Paragraph 2nd of Iraqi Public Health Law of 1981. It says, or it states that the Ministry of Health with cooperation with other related concerned ministry, they are responsible for combating and controlling infectious disease to prevent their leakage from outside of Iraq and vice versa. The significance of enacting a specific act, it's really important in any country to respond to such pandemics like COVID-19 at the level of legislative authority to enact specific acts. Because if a country enacts a specific act to combat such disease, it will enable the government to react or to act with a wider discretion in order to combat or to prevent the spread of such virus. Okay, now let's turn to the third topic, which is response to COVID-19 at the level of executive authority. Since the emergence of COVID-19 in the Kurdistan region of Iraq, numerous of measures have been taken by the government. The first measure that the government took was forming a high committee chaired by the Deputy of Prime Minister and with the members of concerned ministries such as Minister of Health, Minister of Interior. I'll be explaining the measures that have been taken by the government at different levels. The first measure is international travel ban. After the emergence or the arising of COVID-19 case, after the first case confirmed, the Kurdistan region of Iraq banned travel to Iran from Erbil and Slemania International Airport. And it also prevented the entrance for travelers who have visited Iran from 5th of February 2020 onwards. The government also stopped the issuance of visa for passport holders of the following countries, and it also prevented the KRI citizens from visiting such countries, and the countries are China, Iran, Italy, Japan, South Korea, Thailand, Singapore, Kuwait, and Bahrain. And it also, the Iraqi citizens that have visited the above mentioned country after 1st of January 2020, if they wanted to come back to Kurdistan, they had to be checked, be tested to find out whether they are infected with the coronavirus. And even if their test was negative, they had to be quarantined for 14 days at least. The Kurdistan region of Iraq also decided to ban travel between the Kurdistan region and the federal Iraqi provinces from 14 March to 23 of July 2020. The government also decided to close the borders with Iran, Syria, and Turkey except for trade. So the travel between Iran, Syria, and Turkey was allowed only for the purpose of trade with restricted conditions. The second measure that the government took was regarding reducing the government's office working hours. The government decided to reduce the working hours from 8 a.m. to 1 p.m. from 1st of March to 10th of March. And the government also decided to stop the fingerprint attendance system. The third measure was closing schools and university. The government decided to close all the public schools, private schools, and kindergartens from 26th of February to 10th of March 2020. And then the government decided to close the public and private universities from 29th of February to 10th of March 2020. And usually in Kurdistan region of Iraq, we have spring break from 10th to 23rd of March every year. So the universities and schools remain closed at this time. And even the government decided or declared public holiday from 12th of March to 10th of May for all the institutions except health institutions, and law enforcement institutions. And fourth measure regarding the religious affairs. The government decided to suspend Friday prayers from 14th of March 2020. After the situation got exacerbated, the government decided to close the mosques, not even suspending Friday prayers, and all the religious ceremonies banned, whether for Muslims and Christians and or other religions. The fifth measure was regarding the curfew across the Kurdistan region. For the first time, the curfew was imposed on the cities of Erbil and Suleymania from 14th of March until 18th of March 2020. But after the situation got exacerbated, the government decided to extend the lockdown throughout the whole Kurdistan region until 27th of May 2020. And then the government lifted the lockdown. However, because of the increasing of COVID cases, it then imposed the total lockdown from 1st of June to 6th of June 2020. The sixth measure that the government took regarding tourist resorts. The government decided to close all the tourist resorts in order to prevent the crowd. And seventh measure regarding the sports events. The government decided to cancel all the sport events except the Iraqi FA Cup, which took place without the attendance of spectators. And the eighth measure is regarding mask mandate rules. Since the emergence of COVID-19 in the Kurdistan region of Iraq, the government decided to make wearing masks obligatory in public places such as shops, restaurants, and public transportation. The government obliged the owners of such places to not allow the entry of people to such places without wearing masks. However, after lifting the curfew completely, the government make wearing masks obligatory for all the people outside. If they breach the rule of, if they come out without wearing a mask, they will be fined about 20,000 Iraqi dinar. Okay, let's move to the final subject of my presentation, which is legality of the orders of the executive authority. As I explained, that a number of measures have been taken by the Kurdistan region of government. And I say that the legislative authority has not enough any specific law regarding combating COVID-19. Therefore, the legal scholars or the legal practitioners believe that some of the measures that have been taken by the government are not legal. They are illegal because they are not backed up by any law that's been issued by Parliament. Therefore, it's very important before doing anything to combating such disease, first to enact a specific act in order to provide the government, to provide the executive authority with a wider discretion, with a wider authority to combat such diseases. Regarding the distribution of vaccines in the Kurdistan region of Iraq, the country as a whole, Iraq and Kurdistan region of Iraq, has started the distribution of vaccines last month, and they have started first. They've been given to the employees and workers who've been in front line of combating COVID-19, who are working in hospitals, and for the elder people. In conclusion, we just explained 4 topics. First, regarding the spread of COVID-19, response to COVID-19 at the level of legislative authority, response to COVID-19 at the level of executive authority, and legality orders of executive authority. If I have still time, I will just mention that the government has restarted imposing the strict conditions due to the rising of the number of cases that have been confirmed every day, because the cases now are fluctuating from 500 to 1,000 per day. Therefore, the government has decided to reclose the schools and the universities. And that's all for me. Thank you for your listening, and I will be happy to answer any questions if you have. Thank you very much.
Okay, thank you, Dr. Ahmed, for providing us the situational condition in the Kurdistan region of Iraq. You said previously, the government locked the public facilities such as school, university, and then also religious places, which are have been imposed in Indonesia. And we already know how the legislative and executive to respond to the pandemic. Thank you again. Now we move to the third panelist. Last but not least, we are going to hear from the third speaker, Dr. Nirmala Pillay. As you can see on the screen, the short bio of Dr. Pillay.
Well, good morning, everybody from the UK. Can you hear me?
Yeah, your sound is great, Dr. Pillay.
Okay. From the UK, and I must thank the organizers. I'm delighted to be here, and also to meet former students and people with associations with the Leeds Beckett University UK. Well, today I'm going to be talking about the pandemic and civil liberties, and I'm going to do this with respect to comparing what the UK has done to international rules and regulations. So the features of the SARS-CoV-2 coronavirus pandemic, which really caused difficulties for governments in their efforts to contain the spread of the disease and keep the death rate down, were the following. First, it was airborne, infectious, a lethal disease, and transmitted through human interaction by infected people who may or may not have been aware that they were carriers of the virus. In other words, asymptomatic. So the UK government in the early days struggled to formulate a clear policy, and it was not helped by the fact that mistakes were in fact made by modelers, by scientists, and even by economic forecasters. So in the next 15 minutes, I'm going to concentrate only on the impact of the UK government's legal and policy decisions for civil liberties and human rights vis-a-vis international human rights norms. And I'm going to accept as a starting point that restrictive measures were in fact necessary under the circumstances. So the self-understanding of the United Kingdom is of a democratic, rights-respecting, high-income country with a strong rule of law tradition. And so the instinctive response to the disease when it became clear that some action was necessary to stop its spread was to exhort the public, voluntarism, and social responsibility. However, on March 23rd, 2020, the UK Prime Minister had to instruct the British people to stay at home. And 3 days later, regulations were adopted to enforce the restrictions, that these restrictions were even more stringent than the Defense of the Realm Act 1914 and Emergency Powers Defense Act 1939, which were the two acts promulgated during the First and Second World Wars. So first we had the coronavirus regulations, and now we have Coronavirus Act 2020. This act authorized broad-based powers, and it was fast-tracked through Parliament. So specific measures were actually left to delegated legislation. In 1984, the United Kingdom had promulgated an act at that time, and it was called the Control of Disease Act. And that allowed for restrictive measures in instances of infectious diseases. So the new regulations came under that act. And it was a little bit confusing because the three areas of the UK, Scotland, Wales, and the United Kingdom had slightly different rules. So these measures, as of March 23rd, was or were no contact with people outside a designated bubble. Any outside gatherings of more than 2 people could be dispersed with reasonable force. Businesses were shut, schools and universities moved online, and hundreds of elective and non-emergency medical procedures were canceled in the hospitals and in our NHS to prioritize, of course, COVID sufferers. So those of you who are familiar with UK common law would be aware that the instruction to the British people to confine themselves to their homes and only to leave in exceptional circumstances such as shopping and exercise is a severe deprivation of liberty. And under UK common law, and I'm going to read the law, a requirement backed by criminal sanctions to stay at home, which constitutes a deprivation of liberty, is imprisonment. So the difference in this case, what makes what happened here not actually imprisonment, although under UK common law it would be regarded as such, is that people were following the law to stay at home. So we agreed to stay at home. And the regulations will only really kick in if somebody decided to ignore the law. So given the extent of the curtailment of liberty, the law that has been, the coronavirus 2020 law has actually been criticized because of its lack of clarity. So basically the scholars are saying that if you implement a law so close to imprisoning the population, you have to have very, very clear instructions. The Coronavirus Act 2020 is in large measure within the exceptions allowed in domestic, regional, and international human rights law, meaning that the lockdown was in fact lawful. International law permits emergency regulations and the curtailment of rights and freedoms in cases of protecting the public for health and public safety. For example, if you look at Article 3 of the Principles of the International Health Regulations drawn up by the World Health Organization, it respects the sovereign right of government to legislate and to implement legislation in pursuance of their health policies. So international law allows for lockdown, allows for restrictive measures. However, safeguards are built in, provided the regulations shall be implemented with full respect for the dignity, human rights, and fundamental freedoms of persons. Article 5E of the European Convention of Human Rights, which the UK comes under, protects the right to liberty and security of people, but it also allows deprivation of liberty under exceptional circumstances, and these include the spread of infectious diseases. So the convention was incorporated into UK domestic law in the Human Rights Act 98, so we come under the convention rules and the convention exceptions. However, in spite of the fact that international law does allow for these exceptions, the European Group on Ethics and Science and Technology warned that emergency legislation by European countries aimed at bringing the pandemic under control should not lead to long-term erosion of rights and liberties. In other words, the pandemic shouldn't be exploited to put in laws that remain long after the threat of the pandemic is over. So there are safeguards built into the UK Coronavirus Act. The powers granted by the Coronavirus Act 2020 pertain to the transmission period only, the transmission control period only. The act is time limited, and barring exceptional circumstances, it will expire in 2 years. The act is also subject to parliamentary review every 6 months. Also, the powers exercised must be necessary and proportionate to achieve the aim of the act, and that is in the best interest of the person, for the protection of other people, or for the maintenance of public health. However, several scholars, as I said already mentioned, have criticized this act for its lack of precision and for the levels of discretion it allows. The bill has allowed for, with the Coronavirus 2020 bill, has allowed for very intrusive powers. So the lack of explicitness of language is a bit troubling. This is because the laws were made in haste and they were not carefully scrutinized before enactment. For example, there was confusion over regulations and official advice. Even the police were confused, and some people were shamed and fined who may have been ignoring the advice, but they were not in fact breaking the law. So there was general confusion. And one exasperated judge, Lord Sumption, said that this went against the fundamental rule of law principle that enforces the law and not the preferences of ministers. So the judges of the country and the press were keeping a vigilant eye on this. Another example of inexplicit language is that the enhanced powers of the emergency regulations would be exercised by relevant persons. And the words relevant persons in the Act wasn't in fact defined. This can mean it doesn't have to be a public health officer who detains a suspected infectious person. It could be a police officer or an immigration officer. So the level of discretion is very wide if somebody who does not have professional expertise has to make a decision about what is necessary and proportionate under the circumstances. Now, how troubling are these problems with the Coronavirus Act 2020? I don't think they're terribly troubling for civil liberties in the long term because the act is likely to expire. So it is unlikely to have a deleterious effect on civil liberties in the long run. The legislation will expire. A more serious impact on civil liberties is going to be the trade-offs that are likely to come as we learn to live with the virus. For example, compare the approach to the pandemic in the UK with the approach in Taiwan, a country that imposed no lockdown, but kept the pandemic under control and the number of deaths low through a test, track, and trace system. Taiwan was, of course, better prepared as they had previous experience with SARS. However, by keeping the society open, the economy was marginally affected, schools and universities continued as normal, and the number of deaths low. The authorities achieved this by restricting the borders, testing incoming travelers, and tracking and quarantining infectious people. This required a different kind of encroachment on civil liberties, access to personal data, and denial of privacy. The test, track, and trace system required the names and addresses of people, all their contacts, and in cases where people had visited restaurants, their credit card invoices to track them. Now, Article 45 of the International Health Regulations of the WHO allows for the harvesting of personal data. But again, safeguards are built in and it regulates its use and storage. Health authorities may collect information relevant to dealing with a health crisis, where essential for the purposes of assessing and managing a public health risk. Personal data must be relevant and not excessive in relation to the purpose. The data should be accurate and up to date and not kept longer than necessary. Now, I have not done an in-depth study into Taiwan, so I cannot assess whether the Taiwanese government has remained within the data protection rules. But in the UK and in Europe, there is a deep distrust for how personal data is harvested by the state, used and stored. There are stringent data protection rules to ensure respect for privacy. The argument of the Taiwanese health minister is they took all the measures necessary to ensure life as normal. And their approach was not to confine the healthy and to keep the society working normally. Europe, which is now in the grip of a third wave, were forced to restrict and fine people for activities that would otherwise have been perfectly normal and lawful. At the same time, the elderly, who were not at risk, were not sufficiently protected. And in time to come, the human rights of the elderly will certainly be scrutinized in future public health inquiries. However, the question we will face is whether we accept the risk of heightened surveillance and monitoring by giving up large amounts of personal data to the state. rather than repeated physical lockdowns. As of yesterday, the day before yesterday, the UK has announced new rules, which will come into play on Monday, where UK citizens will have to use QR codes when we visit restaurants in order to enable better tracking and tracing. So to sum up, ladies and gentlemen, my point is that when we are dealing with an infectious disease, the encroachment on civil liberties is automatic. Sometimes it is necessary. The question is, what will the population bear? How much of the physical restrictions and how much of the intrusions on privacy? And either way, we will have to compromise, provided the press and the public keep a vigilant eye on the amount of power transferring to the state. Thank you.
Thank you, Dr. Pillay, for your insightful presentation. Pardon me if I forget before to announce your short bio, but Dr. Pillay is a reader and postgraduate course director academic at Leeds Law School, Leeds Beckett University, and Dr. Pillay's main interest is in constitutional law, philosophy, and human rights. And lastly, as alumni of Leeds Beckett University, it is a great honor to be on the one panel with you, Dr. Pillay. Thank you. As I noted, UK struggled to formulate the policy since the factor of politics, law, and economics. The UK have enacted the Coronavirus Act to combat the spread of the virus, but there is a lack of clarity of there is no clear stipulation on that act. So there is a problem on the implementation of the law. And Dr. Pillay also explained about issue on the data protection by comparing Taiwan, UK, and Europe. Thank you, Dr. Pillay. Now we move to the Q&A question. I have noted 2 questions written down on in the chat column, so I will read it for you. Okay. For the first question, comes from Andi Alia. This question specifically to Ms. Giselle Durana, but I think 2 other speakers can give a what particular aspect of COVID-19 regulation in the Philippines which can become a set of positive example, or alternatively a grim lesson to be followed by other countries? So please, Ms. Giselle Durana.
Good afternoon. Thank you, Andy, for your question. I think the positive aspect, if any, from the COVID-19 would be it in a way speeded up the transition of government transactions here in the Philippines from face-to-face transactions to technological alternatives, which would discourage or would prevent the physical appearance of the clients in government agencies. So that not only curbed the spread of the virus, but it also expedited the transactions with the government, which was formerly the subject of numerous complaints from the public because of slow actions on the public's requests or the transactions. On the other hand, what's the other question? The grim lesson that we can take from COVID-19. I think, in my personal opinion, one of the grim lessons which we can get from the COVID-19 pandemic, especially here in the Philippines, is that decisions of decision makers must be based on science, since COVID-19 is a virus and not on politics. So that's it.
Thank you. Dr. Ahmed, do you have any example from your country? What is the best positive?
Thank you very much, Mr. Ahmed, and thank you for Hugh. I think he has asked us question for all the 3 speakers regarding Iraq. As I mentioned that in Iraq, some of the measures that have been taken by the government and by the Kurdistan Region of government, I personally think they are illegal because, for example, as you mentioned in your question, travel restriction and the lockdown or restricting the freedom of people, any action that violates such rights, they need to be backed up by a specific act that's enacted by parliament. However, as I mentioned in my presentation, in Kurdistan Region of Iraq and in Iraq as a whole, no specific act has been issued by the legislative authority. Therefore, I believe that the example that you mentioned, the measures of the government in Iraq and in Kurdistan Region of Iraq, they are not legal.
Thank you. For Dr. Nirmala, may you give us some thought about the positive aspect from the UK law of the COVID and what your thought about the lockdown? Thank you.
Well, I'm just looking at the question here, which is asking about restriction on freedoms and whether it's a violation of human rights, and with reference to the previous speaker as well. The difficulty we have is that we are not dealing with absolute rights. We are dealing with qualified rights, and these rights in international law, they allow for exceptions. So the question is whether the Coronavirus Act or any act by any government is within the exceptions. If a government issues executive orders, as the previous speaker, and these executive orders are very intrusive, and doesn't do it through proper legislation and a proper legislative process, then we start getting into difficulties. So when you are dealing with restrictions on liberty, it is better to have a thorough and well scrutinized law that does that, rather than issuing executive orders. And of course, the law has to remain within the safeguards allowed by international norms.
Thank you, Dr. Nirmala. To be honest, we still have 4 other questions, but all speakers may indirectly have answered for the other question. So the 3 panelists for the first panel have done their presentation and done the Q&A session. So to proceed to the second panel, I have to say thank you for you all for your great presentation. I hope we can see another time in another occasion. Thank you. So I hand over back to Master of Ceremony, Ms. Fadilla Jamila. Thank you.
Thank you so much, Mr. Fahri, and thank you for 3 of our wonderful speakers. It is very thoughtful to hear the perspective from COVID-19 in the Philippines, Iraq, and the United Kingdom. Thank you so much for sharing with us. It was a very interesting sessions. I hope all the participants are having a great time. For your information, the committee will be sharing the attendance link in the chat column later on the second sessions, so please check it out. Now, we will be moving to the second panel session, and it will be guided by Mr. Riyad Febrian Anwar. He served as lecturer at International Law Department here in Law Faculty of Hasanuddin University. He graduated his undergrad in Hasanuddin University and pursued his master degree majoring legal research in Tilburg University, the Netherlands. Without further ado, let me present Mr. Riyad Febrian Anwar to lead the second session.
Good afternoon. Can everyone hear my voice? Okay. Hi, everyone. My name is Riyad Febrian Anwar. I am the moderator for this session, this second panels. But before that, let me formally express my gratitude to the honorable lecturers of Rector of Universitas Hasanuddin, represented by Director of Partnership of Universitas Hasanuddin, Dr. Mahatma Lanuru, and also to Honorable Dean of Faculty of Law, who present before, and also to our respectable chair committee, Dr. Birka, who provided us with the event report previously. And of course, with the honorable speaker who come from different parts of the world, to name Prof. Jonathan Verschuren from Tilburg University, the Netherlands, Prof. David Linnen from South Carolina University, Dr. Bzhar A from Soran University, Kurdistan Region of Iraq, and Dr. Nirmala Pillay from Leeds Beckett, United Kingdom, and then Ms. Julie Kusimba from Nairobi, and then Ms. Giselle Durana from Manila, the Philippines. Thank you very much. In the previous panel, we have presentations related to the response and reactions about COVID-19 measure, which was implemented in the Philippines and also in Kurdistan region of Iraq, and also in United Kingdom with further explanation of interplay of human rights and public health emergency that occurs when implementing these measures. I think the one particular comment that I would like to say, especially related to human rights and then the implementation of COVID, is that when we see the COVID-related measure and then legal advocate demand such law to become crystal clear, because the more restrictive it is, the more it seeks to, it has to be defined clearly. Then there's also these questions about how we could create a COVID responsive law, which is require a lot of extensive research, and then sort of like creating a backup to justify, yes, we try to impose this particular measure because we think this is the most scientific reliable one. Well, this is sort of a question that I hope we could further elaborate. But in any case, today we're going to present the second panel. The second panel theme is legal landscape in the post-pandemic era. If the first panel focused on the response and what happened currently in the past and lesson from the in the present, in the second panel we focus on thought playing to imagine what is the future hold for us if the coronavirus persists, or eventually if COVID ceases to exist because everyone managed to be globally vaccinated. But then what next for us? Now, in this panel, we have three speakers. First, Ms. Julie Kusimba, who will present about COVID-19, a wake-up call to Kenyan legal regime. And then Professor David Linnen, who is going to present about the social effect of pandemics and legal consequence. And last but not least, Professor Jonathan Verschuren, who is going to explain about reducing risk of future pandemic through environmental law. Now, to start this session, I will invite Ms. Julie Kusimba. But before that, let me read briefly of her CV. Ms. Kusimba worked as legal officer at Area Finergy Holding in Kenya. Ms. Kusimba previous professional work, including research assistant on ethics and anti-corruption commissions, and also overseas preparation in 2018 national election in Kenya. And then Ms. Kusimba also took master degree in University of Leeds, majoring international corporate laws. Apparently, we have a lot of Leeds hype in here, so we welcome that. Now, without further ado, I invite Ms. Kusimba. Time is yours.
Thank you very much, Anwar. I hope everyone can hear me.
Yes, crystal clear.
Thank you. I will begin by sharing my screen. Just a minute, thank you very much, Anwar. Okay, I will begin by the first. So I will be taking through the law in time of COVID, the response, effect, and future legacy, with a particular focus on Kenya, and why this pandemic has been a wake-up call for the Kenyan legal system. Like all other parts of the public life, the administration of justice and access to legal remedy and dispute resolution have been severely disrupted by the COVID-19 pandemic. The first case in Kenya was announced on March 13th, and 2 days later, the National Conference on Administration of Justice issued a notice, released a statement led by the Chief Justice on the measures being taken to address the COVID-19 outbreak. So for the Kenyan legal system, I've noted that it's from Ms. Giselle's presentation, it's similar to the Philippines legal system, where the legal practice involves physical attendance in courtrooms, where attendees physically present their cases. It also involves a lot of handling of physical documents. So in Kenya, the main dispute resolution mechanism is litigation, which is done through physical attendance. Others include mediation, arbitration, and negotiations. So the litigation mostly involves open court sessions, which I have mentioned involve human interaction and use of physical documents. So from the statement released by the Chief Justice on measures being taken to address the COVID-19 pandemic with regards to the legal system, all court sittings were suspended except for urgent matters. Foreign travel for justice institution staff was suspended. All physical meetings, conferences, workshops, or trainings were suspended as well. Bringing prisoners to court for remand hearings was suspended. And open court for public participation was also closed, and it was only open to 3 members of the judiciary, that is the judge or the magistrate, the court administrator, and the court assistant. So we now move to the impact of the pandemic on administration of justice. During this period, all appeals, hearings, mentions, execution proceedings, especially in criminal cases, in all courts were suspended. Only filings accepted in the court registries were certificates of urgency and time-bound pleadings. This is because I had mentioned earlier, most pleadings in Kenya are drafted physically. So we didn't have an e-filing system, and what we had not picked up yet. So at that moment, every pleading had to be filed at each court registry. So it involved a lot of exchange of documents between the advocate and the court registry attendees. So because of this, the judicial sector was now forced to embrace technology and conduct its matters virtually. So the e-filing system had to be introduced and to be implemented immediately. You can note that earlier, the e-filing system in Kenya had been introduced, but implementation had not taken place. It had been a very slow process and fought by very many advocates because most of them did not know how to do it. Court proceedings also moved to be conducted virtually. They now embrace the use of Zoom, Teams to continue with the court proceedings. However, with the embrace of technology, the judiciary lacked this technological infrastructure. There were very few computers to be used by the industry players in the criminal justice, computers and the judges themselves, and even in prisons. You would find there would be very few computers, maybe 1 to be used in a particular prison, so court pleadings would not go on. And even in police stations and for the prosecutors, they were not enough. So you can also note that some of the key industry players, like the police, the advocates, and even some of the judges, lacked the technological know-how. There were difficulties for them on how to use the virtual platforms. Some of them dropped off, and this delayed so many proceedings. There were also difficulties on going about the e-filing system. People didn't know how to go about it. It took so much time to file pleadings through this system, and sometimes the system itself would crash. Another impact on the administration of justice, Another impact on administration of justice was locking out the public from participating in cases. This is because of most of the public lack computers or even mobile phones that would allow them to join cases virtually. This locked up public participation, and also sometimes witnesses would not be able to join the proceedings. Because of this suspension of court of proceedings, especially the open court proceedings as they would have been done earlier, there has been a huge backlog created to an already existing backlog. So no new cases, especially in the High Court for criminal cases, have been heard since March 2020. For the civil cases, some of them have been heard, but very slowly because of the technical difficulties. Ongoing cases, appeals, and matters certified urgent were the ones being conducted virtually only. Or we can now move to the impact on contractual agreements. The government imposed restrictions in Kenya. These restrictions included a curfew that was between 5 a.m. to 7 p.m. in the evenings. There was also a restriction of inter-county movement. There was also close of borders, especially on the Tanzania border and the Somali border. So some of these restrictions imposed by the government delayed many businesses in meeting their supply chains, thus putting stress to their contractual obligations. The general rule under contract law is that where a party fails to perform its contractual obligations, such failure constitutes a breach of contract and gives rise to liability in favor of the counterparty. So during this period where many businesses were stressed in meeting their obligations, contracting parties were forced to find ways to mitigate these losses and liabilities in their performance. So most of them were forced to rely on the doctrine of force majeure and frustration to either delay performance or alleviate liability during this non-performance. So others were forced to have to renegotiate their contracts so as to vary them and to make amendments to be able to suit this pandemic period. We also have the impact on property transactions. The land and property regime in Kenya is very human interacting. It involves a lot of physical attendance, a lot of exchange of documents. So this was highly impacted by this pandemic. From pre-contractual negotiations in land and property transactions, they mostly involved physical and human interaction. So there's the movement to have to go to a site visit, there's the preparation of documents, which involves a lot of exchange of documents from one person to the other, and also the filing of documents in various land registries. All processes in the land involved in land and property transactions were suspended. This is because all land registries were closed. Most of the land registries attendants would fall sick because of this exchange of documents and having to deal with face-to-face with people. So people in serving these areas used to get sick a lot and the virus would be transmitted very fast. So because of this, land transactions stalled and many people lost their livelihoods and their source of income. And due to this pandemic now, the land regime is slowly embracing the e-filing and are now conducting business through virtual means, hybrid means. This is both virtually where some of the systems have embraced e-filing and physically where they have not been able to make any changes to the system. I will now move to some of the key highlights, key legislative highlights, developments. There have been some changes in corporate law to cushion people because of this COVID-19 pandemic. So some of them include where the Companies Act brought about guidelines on how to conduct virtual and hybrid meetings. Previously, the Companies Act had been silent on conducting virtual meetings, especially for AGMs. Now companies have been allowed to do a combination of either online and physical general meetings. This is, the Companies Act has also now provided for written resolutions in lieu of physical meetings that have the same effect as resolution passed in general meetings. There's also been, public companies have now been allowed to hold their general meetings either virtually or hybrid, depending on what their articles of association provide. So there has been that flexibility of conducting some of these meetings virtually, whereas before most of them would be conducted physically. In the commercial and property transaction sector, there was Business Laws Amendment Act 2020 that came to effect immediately prior to the announcement of the first case in Kenya. This Amendment Act has had a very positive effect, and it has eased doing business in Kenya. Some of the notable developments are the recognition of e-signatures for commercial transactions, recognition of electronic stamping and registration of documents, and the simplification of land transactions. You would note that up until this 21st century, most of this and virtual technological infrastructure and developments had not been adopted in the Kenyan legal system. So this business amendment law brought that into effect, and people were able to transact using these e-signatures. The other measures were the tax measures. Most of these legislative changes were introduced as measures of dealing with the COVID effect. These changes largely were implemented to reduce the impact of the pandemic on the Kenyan taxpayers, while also balancing the country's economy. So the changes included change in turnover tax, which is mostly applies to businesses whose turnover is $10,000 US. So this turnover tax was reduced from 3% to 1%. There was also the removal of presumptive tax, which also applies to businesses that pay turnover tax. This presumptive tax used to be 15%, and it was removed so as to allow to cushion the business people. The introduction of compensating tax. There was also a reduction of corporate income tax, which was reduced from 30% to 25%. Reduction of income tax for employees was reduced through their different bands. And also there was the reduction of VAT, which was reduced from 16% to 14%. All these changes were done so as to cushion most of business doers and also the citizens of the country. I will now finish with some of the recommendations, which are mostly investing in infrastructure. The judicial system has been trying to invest in infrastructure because some of the places actually lack courtrooms. So you can imagine now we lack courtrooms, and now we need to add computers and add security software. So that process needs to be hastened, and a lot of investments need to be done. They also need to provide internet and power backup, and also to make them available to the public. The judicial system should also provide training on how to use this technology, both to the judicial industry players and the public who use these systems. Also embracing and sensitization on using online transactions and providing a legal framework for the use of these online transactions. That is it from me, and thank you very much.
Thank you very much, Ms. Simba, for the amazing presentations. There are two important highlights for me personally that we could further discuss about the features of the laws in post-pandemic. One in particular is the point that pointed by Ms. Simba related to digitalization preparedness. As we can see in several speakers already, we discussed a lot about e-filing to streamline the court process. What is interesting is that there is a realization when we try to implement digitalization preparedness, it is a two-way round. Not only government has to ensure its ability to maintain such digital platform, but also to ensure that the society itself capable to operate the Internet of Things. Like my mom only able to operate Facebook. Like it will be hard to ask them to open Google form and to fill the vaccination form. So that's one of the challenge. And another one related to the use of doctrine of force majeure. I think this is an interesting one because not just in Indonesia, I believe probably also in Kenya and different part of the world, the usage of doctrine of force majeure has increased dramatically. And then we're going to see how it evolves globally in the futures. What is the limitation? How far it could go? that is definitely some interesting takeaway in here. Thank you very much, Ms. Kusimba. Now I proceed to the second speaker, Professor David Linan. Hi, Professor. Okay, let me read briefly about Professor Linan's bio. Professor David Linan is a scholar of comparative law, economic, and public international law with special interest in Asian law. Professor Linan has held research or teaching appointment at the University of South Carolina, University of Seattle, the Australian National University in Canberra, the University of Melbourne, and in Indonesia in Faculty of Law and Graduate Law Program in Jakarta, the International Undergraduate Program of Gajah Mada University, and in Max Planck Institute in Freiburg, Germany. Now, Prof. Linan will present us the social effect in pandemics and legal consequence. And without further ado, we invite Professor Linan. Please, sir.
Well, first of all, I'd like to thank the committee for inviting me. It's been a long time since I've been in Makassar, virtually or otherwise. I would say that I adopted another approach, and let me explain what it is, and then we'll share screens and start working our way through the papers. I look at this less in terms of whether the courts, for example, have gone digital, and I can talk about that in the discussions if you'd like, but otherwise, I'll put it up, okay. But otherwise, the real question are what I would call the sort of social effects of the pandemic, because it's a combination epidemic, which is sort of a public health problem, and it tends to be also combined with a recession, which is an economic problem, because when you basically shut down, for example, businesses to preserve public health, of course, there are no sales. So my approach is to go through, sort of bring up some of the consensus social science effects, and then ask how they, at least prospectively, affect a variety of sort of issues. And under those circumstances, we'll wind up asking sort of questions at the very end about Indonesia. Now, if you, oops, okay. If we start with a problem of social effects, I would say there's what I would call a scientific literature, and it's actually got at least 3 parts. There is an economics literature that goes back to an interest in the United States in economic effects of recessions that was really sort of created in the wake of the 2007-2008, what we call the Great Recession, because suddenly there were large amounts of people who were out of work, and then there were young people who started their careers in the midst of a recession, and the economist's question was, what was the effect of this? There is also, interestingly enough, a public health sort of literature in which the public health and medical people have kind of rediscovered the history of medicine, because they go back and see how people, particularly prior to the sort of creation of vaccines, used to deal with epidemics. And as a practical matter, they've examined closely the sort of Spanish flu of 1918, 1919 as the most comparable epidemic, but you actually have the medical doctors writing about it. And then finally, you have the, let's say, the political scientists observing what you might call sort of populism and nationalism. And this is associated in part with sort of lean economic times. So there is some overlap between the economists and the political scientists, but there is actually a literature. And if you then say, are there any practical effects of having the pandemic? Well, we would say, for example, in the United States, I think it's commonly accepted that President Trump was not reelected because people thought he did not do a good job managing the pandemic. So essentially, that's the kind of effect that brings with it, let's say, a new administration, different policies, but that's the kind of thing where we can actually look at something that came out of the pandemic. So let's keep going and bring up something else. When I was first asked to speak about 3 weeks ago, actually, I thought about whether I would have to say something about POSO. And for the benefit of my non-Indonesian colleagues, this is an area in central Sulawesi, which has been over time the arena of significant interreligious conflict. And my presumption was, because of the problem of sort of social pressures, I was going to have to say something about watch out for something bad happening in POSO in the not too distant future. And then probably the Indonesians know this, but maybe my foreign colleagues don't, but there was a bombing about 10 days ago at the Makassar Cathedral, the Catholic cathedral. And essentially you can talk about whether this is an accident, but I think the presumption is where there's a lot of social pressure, it will find an outlet. And so the obvious question is sort of whether there is any connection. And my particular interest in this has to do with something that I did just before Indonesia shut down, because in August of 2019, I launched a book entitled Kata Bersama Antara Muslim dan Kristen, co-edited with several other academic friends or acquaintances, and I think the Indonesians would recognize some of them. Ibu Harkristuti Harkrisnowo from UI, who was sort of in the old guard for human rights. Paripurna Sugarda from UGM, who's a commercial lawyer, but he's also sort of involved in some of these questions at the university level now, because he's the Wakil Rektor M4, I guess, at UGM. And then Siti Ruheni Tsuhayatin, who is originally from UIN Jogja, but I think currently is in government. And then another colleague, an Egyptian American, Walid El Ansari. But we looked at this, and in particular with Paripurna, we sort of wrote something that I would say is the sort of question of how do you deal, for example, with ISIS in an Indonesian university. I bring this up simply to say I don't want to talk about that very much, only in passing, but it would be irresponsible not to refer people in a very sensitive topic to outside sources if they want to read more details. My own view actually about the pandemic was expressed originally in a sort of a thought piece with another academic friend, Lindayanti Sulistyawati. We published something in the Straits Times in May of 2020. And essentially, our conclusion at the time was that that you would have to say that the COVID epidemic was actually what we would call a dress rehearsal for climate change problems in terms of economic and social pressures. We'll sort of leave it at that and proceed ahead. If we go ahead and we talk about social effects, we'll go through a list quickly. In terms of negative social effects, when you talk about lockdowns, quarantines, and the closure of international borders, actually that in the short term has an effect, on the economic sort of climate generally. That's where recessions come from. But it also exacerbated pre-existing economic changes like changes in global supply chains, increased national debt, and greater government intervention. And this is in particular, I think, a problem for developing countries. Another social effect is essentially what I would call exclusionary nationalism in a domestic sense, and internationally people would talk about vaccine nationalism as a political phenomenon. You also have what I would refer to as deepening inequality within and between countries, because as the economy slows down, it basically hurts poor people more. There's also an effect which is straining governance capacity, because if a government is not dealing well and there are already low levels of trust in public institutions, not dealing well with the crisis, then in fact, the sort of public opinion of government goes down even more. There's also sort of highlighting what I would call failed international cooperation in fora like the WHO and international investigations. And this is important prospectively if you're talking about, are you going to cooperate in areas like climate change as an international matter? And finally, I would say, to a certain extent, it elevates the role of non-state actors internationally, because we would say, while governments may produce some vaccines, most of them come out of the private sector pharmaceutical companies. So there's actually more attention being paid to the pharmaceutical industry and vaccine progress than there is necessarily to whatever is coming out of the Ministry of Health in a particular country. Those were what I would call the negative catalyst. There are some positive ones. One of the things internally in the United States is that the focus on, let's say, the deepening inequality has come up very directly in conjunction with discussions about what should be done within American society. And you actually have senior business people coming out and saying, you know, we really have to do something about this, which is surprising in terms of the way they normally behave. You also see political and economic changes triggered by the pandemic response. I already mentioned the change in the presidency, but there's also ongoing, let's say, arguably a change in views of the proper role of government on account of the public support for the pandemic response. So that the way I think I would explain it to my Indonesian colleagues is actually neoliberalism has become relatively unpopular, simply because the idea of the government keeping out of affairs generally is less popular in the middle of an epidemic. And this works its way down to capital markets and things like the ESG movement, environment, social and governance movement. So you see actual positive effects there. We would say that actually within Europe, and perhaps my Dutch colleague has a different opinion, we think the EU is rallying around an economic rescue package that looks like it may actually help with European integration, which seemed to be lagging a little after the sort of British exit, Brexit. There are other positive social effects. I think in business, people would talk about in 1 year, we have probably made at least 5 years of progress in terms of digitalization, because suddenly when everyone is forced to do everything digitally, there's much more focus on it. So businesses commonly talk about their 5 years ahead of their sort of plan for what they should do in this area. You also see within major cities changes in usage of real estate, and the long-term plan is for major corporations to probably use less real estate and have more people work outside the office. And the other thing that probably may be a mixed blessing is it looks as though business travel will go down, because if you have been meeting with your customers via Zoom for a year, there's a question about whether you really want to get on an airplane and fly for 2 hours to meet them. So the interesting thing is, you could say digitalization, for example, favors some businesses and disfavors others. And the example would be it favors e-commerce, it disfavors retail, what we would call bricks and mortar retail. But you actually begin to see changes. If you turn to from the sort of general social effects to what I would call public health, I've already mentioned this before, but the public health people are going back and looking at the history of epidemics, and they're trying to learn how their predecessors 100 years ago actually did social distancing. And this was particularly important before there were, a good vaccine available. But what they've done now is they're sort of recovering lost social memory to that extent. You could also say, what are the visible social effects in the public health side? Well, unfortunately, there's something in the form of suspicion of foreigners and outsiders as a source of an invisible threat. And the way this has come up is the expression of anti-Asian bias after President Trump referred to COVID-19 for political effect as the Chinese flu. So that has caused some friction. Other social effects, quarantining or isolation behavior, you have a history of that, but also it's beginning to affect people. I don't know if the other university teachers have noticed that, but after a year, my students are getting a little squirrely, I would say. They actually are impatient and want to get back together, as opposed to sitting sort of isolated in their apartments or in their rooms and looking at their computer. You also have a tradition of disproportionate deaths in the medical professions. You have differing access to healthcare and higher mortalities in minorities and the socially weak. And this is visible when you literally look at the statistics for who died and how many people survived in a certain group. And there's a general problem of what to do about susceptibility of groups like the elderly. And this has both some special effects in certain groups, but it also affects ordinary families, because if you're not allowed to go to the hospital to see your grandmother and she expires, this is a big problem for ordinary people. Last but not least, visible social effects. There have been, I think, as of late, 560,000 COVID-19 deaths in the United States. And the common comparison is it's more American deaths than in both world wars. And frankly, that's the reason why Mr. Trump lost his re-election campaign. You see here some representative literature for those who want to follow up on this. I sent a copy of this to Pak Riyad, so he can provide it to anyone at Unhas who's interested. In terms of social effects on the economic side, what happens is, as I said, this was investigated in part in the wake of the 2007-8 Great Recession, which hardly had any effect in Asia, but was like the American equivalent of a multidimensional crisis. And so what happened is, essentially, there's a record of that. We wound up completely redoing our financial sector regulation. And then actually it was because of political behavior following the Great Recession that the political scientists began paying attention to the problem of populism. If you talk about the scientific literature in economics, it's chiefly focused on long-term economic effects on workers, and more directly, it's also focused on the effects of young people entering employment for the first time. For those of us who already have jobs, we adjust, we learn how to use Zoom. But the problem is if companies basically sort of cut back on their hiring because they're not sure how things will work in the middle of a recession, then if you're an S1 graduate coming out of Unhas, it's difficult to find a job. And the question is whether that sort of delay in commencing your career doesn't have a 10 or 15-year effect. So the economic effect that may take place over 2 years during the pandemic may actually affect this sort of younger person for 10 or 15 years because it slows their career entry. If we talk about social effects.
Professor, I think
Yes?
your time has lapsed for quite a few minutes already. I'm so sorry. If you could conclude.
Okay.
Yeah.
That's fine. I suppose the way I looked at this, there were several questions that actually are questions for Indonesia. The greatest challenge for Indonesia in recent times is employment for youths. You know, the rising youth population and the challenge of creating new jobs. The question is, what does this sort of information about the longer term effects of graduating into a recession, what's the effect on Indonesian economic development? There is also a question, for example, about that I'll just pass over in conjunction with to what extent the recession or the pandemic has any effect on things like the Makassar church bombing. And that's a question of what is the relationship between, let's say, general social problems. The next thing would be, for example, you know, of course, Pak Jokowi wanted to move the capital from Jakarta to Kalimantan, but, you know, and that's important if you live in Sulawesi because that's decentralization. But things have slowed down. And so the question is whether in the end they can do it before he leaves the presidency. And depending upon who's elected, whether it's done at all. And the question then is what happens if decentralization slows down or stops, in part because of the economic slowdown. There's a similar question about who would replace Pak Jokowi if the economy is not going well, because I assume it will be another close election. And there's a final question, which is, the Indonesians can tell me what has happened with the working group on Pancasila, which I think hasn't done anything. But if the main political question is who's the next president in 3 years, I think the main legal question is what interpretation might they have of Pancasila, which is kind of left hanging currently in a nationalist administration. But I think the answer to that question depends a lot on, you know, whether the next president comes out of Islamic parties, someone like Pak Anies, or whether they come out of the sort of old line nationalist parties. And I'll leave it at that.
Okay. Thank you very much, Professor Linan. That was fantastic presentation. It's actually really resourceful. A lot of insight from Indonesia, but compared from the perspective of the United States, and also a little bit insight from Europe as well. Then the important point that gets us to transition to the final speaker is that, in Professor Linan's point, one of the interesting things is that COVID epidemic, it's sort of like stage a rehearsal for climate change, and it's also building up to a bigger social and economic issue in the future. And then to lead up to that, I call upon the final speaker, our final speaker in this panel, Prof. Jonathan Persurance. Prof. First of all, my apology to Professor Suran because we are quite late by a few minutes. I know you have really limited time for this session, but let me just go straight to your bio. So Professor Suran is a professor of international law and European environmental law at Tilburg University Belanda. He wrote more than 200 publications in the field of environmental law. And also in 2017, Professor Suran was awarded the IUCN Academic of Environmental Law Senior Scholarship Prize. What is more interesting, Professor Suran is my research coordinator back then in the Tilburg University Master. And then this moment is enlightened moment. I've been looking forward to seeing him again. So without further ado, Professor Suran, time is yours. Your audio is on mute, Professor.
Can you hear me?
Yes.
Can you hear me? Okay.
Yeah, I can hear you now.
Okay, well, thank you, and well, congratulations to everybody at Hasanuddin University with your Dias Natalis and with this great webinar. I would like to say something about the role of environmental law in preventing the next pandemic from coming. And I will briefly talk about some of the things that you see here. So pangolins, bats, logging, chicken farms, and even donuts. My screen is not moving. Yes. So before going into the role of environmental law, I'll have to say a little bit about the background of viruses and what's the relationship to the environment. Otherwise, it's difficult to explain the role of environmental law is. So first of all, viruses are everywhere of life on the planet. They have been here for as long as life is here. And viruses exist mostly in wild animals, and those are called reservoirs. So we're probably all familiar with bats being a very important species that exist as a reservoir. And we have only discovered about 6,000 viruses in land mammals at the moment, but we expect that about 320,000 species exist, and there are many, many more species also in the ocean. So this is really a species, viruses exist really everywhere. Well, viruses can, as we now all know, jump from their reservoir to other animals and humans. This is called spillover, and often such a spillover occurs through an intermediate species, and that is called a host. And often host animals are animals that are kept by humans on farms, for instance, or they can spread through vectors like insects, which is, for instance, the case in malaria. Well, when they enter a human, they can cause a disease. We call this a zoonotic disease, which means diseases caused by animals. And the majority of all human diseases that we know are actually caused by humans. And this number is increasing quite rapidly, actually. And also COVID-19 is an example of that. As you can see on the slide, most people think that COVID-19 is a really terrible disease, and of course it is terrible, but if you look at what viruses can do, then this is actually quite a mild disease, because we also have viruses that have a mortality rate of 100%, which cannot be cured when you get infected. So yeah, it's really important to think about how to prevent the next pandemic from occurring, because the next one might be a more dangerous virus. Another thing that's important to realize before going to the law is that our immune system is also very important. We have a natural immune system that can combat these incoming diseases caused by viruses. But our immune system in a lot of parts of the world it has been affected by environmental pollution, air pollution especially, and also by unhealthy food. So this is very clear also in the mortality figures in COVID-19. A lot of people that died actually have obesity as a consequence of which their immunity system has been impaired. And also the air pollutants that exist in a lot of areas, especially in cities and urban areas, affect lungs and the airways more generally. And that's also something that has affected how humans responded to COVID-19. Well, why is the number of zoonotic diseases increasing or rising? There are a couple of reasons for that. First of all, we are increasingly disturbing the reservoirs through habitat destruction. So especially deforestation is a very important reason why we are getting closer and closer to these reservoirs that have all these viruses. So, and we know that biodiversity hotspots, especially tropical forests, have a lot of animal species that act as reservoirs for viruses. Secondly, we have surrounded ourselves with an increasing number of potential host animals. This, of course, is mostly through livestock farming. So livestock is very close to where people live, to residential areas, and livestock numbers are rapidly increasing across the world, and especially also in Asia. And then the third factor is the number of humans. If you have a lot of humans that live close together in big cities, because of urbanization, and if you also have then globalization, which means that people move around and meet other people, then you can understand that when there is a spillover and a disease occurs, then the spread of this disease will be much more faster than this used to be. And here I just mentioned this comparison to a 17th century sailing ship. When you have a spillover in the 17th century, then it can take months for a virus or a disease to spread. But modern aircraft, a virus can spread around the world in a matter of days. And that's exactly what we saw with the COVID-19 pandemic. And of course, climate change is an important factor as well, because of climate change, animals are moving around, they move to new areas, and this then also means that the viruses that they contain, so this is both for reservoirs and hosts and vectors, they also move to new areas and they can spread more easily. And then finally, another important factor that plays a role here is that we see an increase of the intake of unhealthy food. So overweight people and obese people are increasing in numbers, which has an effect on the immune system and thus helps to create a pandemic. Okay, then what then is the role of law? And that's what I would like to focus on, because now that we know what the background is of the pandemic, of pandemics in general, and zoonotic diseases, we now better understand what the role of law is or can be. First of all, biodiversity law is very important. We have to protect the forests, habitats of species, and you might probably then say, okay, but we already have biodiversity law. We have international conventions on this. We have domestic legislation on protecting forests and other natural habitat types. Doesn't this work? And I think the answer is no, they don't work at the moment. The laws that we have are not stringent enough or are not enforced. And habitat destruction is ongoing, and also biodiversity loss is only increasing despite all the efforts at the international level, for instance, through the Convention on Biological Diversity. Same with endangered species trade. So the CITES Convention, the Convention on International Trade and Endangered Species, has been in place already for decades, but still a lot of poaching takes place and a lot of capturing of animals from the wild is taking place, and this creates a dangerous opportunity for viruses to spill over to humans. So this is a very important area that we have to focus on first, I would say. And this is something that has to happen around the world. This is not something that one country can do all by itself. This really is a global issue that needs a global program to tighten a range of laws, including biodiversity laws, if we really want to reduce the risk of the next pandemic to occur. Then environmental and agricultural law. So it's important to reduce the possibility of viruses to move to a host animal and then from that host animal to humans, which basically means that we have to regulate livestock numbers, so reduce the number of livestock and also the emissions of livestock, of farms, because the emissions, I said something about air pollution. One of the causes of these emissions that have a negative impact on respiratory system are emissions from livestock farms, like ammonia, nitrogen, for instance. So that's another area of law that has to be used to tighten the rules in order to reduce the potential risk of a new pandemic. And then rules on air pollution. This is also kind of a general problem that we have to combat, and it's now evident that's also important from a health perspective. If you look at epidemics and zoonotic diseases, because this affects our immune system. So reducing air pollution, stricter air pollution control from industry and traffic and from farms is important. Then planning law will play an important role. You have to create distance between livestock keeping on one hand and residential areas on the other, so as to reduce the risk of host animals infecting people. And we have to create buffer zones around forests and protected areas. This can also, you can do this, of course, through nature conservation biodiversity law, but you can also use planning law to create buffer zones around protected areas. And then food law, as I already said, our food is not that healthy anymore. And this is something that needs to be addressed as well if we really want to boost food system. So address unhealthy food through taxes, subsidize healthy food products. Maybe you can even ban certain food types that have a negative impact on people's health. And then climate change law, as I said, climate change is impacting the pandemics as well. So tackling greenhouse gas emissions is important as well. So there are a lot of different types of law that need to be used to reduce the risk of a new pandemic. And what's interesting is that the WHO already for quite a while is promoting the One Health concept. And the One Health concept means that human health, animal health, and ecosystem health are all connected. You cannot only focus on hospitals and have a good health system there while you neglect our forests. You also have to protect our forests. They are completely linked to our hospitals in a way. So everything is connected on the planet, and I think this pandemic has made this more clear. So hopefully this then also leads to a drastic redesign of the laws, which is needed to address this problem. Because at the moment, the laws are very fragmented. A lot of different topics that are addressed in a fragmented way, spatially and in timescales fragmented as well. All levels of governance need to work together, and big systematic changes are needed as well. Also, I take out here one example, the food system. If you really want to stimulate healthy and sustainable food, there's quite a big program that needs to be in place to make that happen. And not just in one country, but across the world, because we are all connected. We really live on one planet, and our health depends on all these other actors and all these other species as well. So now you understand why I discussed all the topics: pangolins, bats, logging, chicken farms, and donuts. They're all linked together, and they're all relevant if we aim to prevent the next pandemic. So thank you for your attention, and terima kasih.
Terima kasih, Professor Suran. Thank you very much. So what we're going to do right now, we're going to entertain Q&A session. We already seen several questions here, and I'm going to do it based on the reverse order. So start by Professor Suran, and then followed by the Professor Linan, and then by Ms. Kusimba. So I see one question provided by our first moderator, and the question is, you are correct concerning biodiversity protection. There is much more attention to climate change in carbon generation terms. So we have the Paris Agreement, but the Biodiversity Convention has never taken off the same way. Why is this? How can you really motivate pursuing biodiversity in the same way to have plan to address carbon tax? Please, Professor Fachri.
Yeah, that's a very good question. I'm afraid that we don't really see biodiversity loss as a very pressing issue at the moment, or at least until the COVID-19 pandemic. Hopefully that will change now. I think for climate change, this has also taken a lot of time. Now, gradually, I think the world is understanding that climate change is really a big issue and needs to be addressed through a lot of different measures and a complete new way of energy production, and well, everything has to be changed actually. Biodiversity loss, this is not yet the case. We generally, I think, don't think that politicians and people around the world have the same sense of urgency. But basically, this COVID-19 pandemic is a biodiversity problem. That's actually the case in my view. So this shows that that we need a similar effort by the international community and everybody, not just the international community, but all local communities, everybody around the world, to address biodiversity loss as well. And hopefully that is that is one of the good things that might come out of this pandemic, is that we now start to realize and start to tackle biodiversity loss as well.
Thank you very much, Professor Fachri. Now we proceed to the question by Muhammad Nawir. How about regulation COVID-19 in Indonesia, that many pro and contra, for example, human rights, social culture, corruption, government in the pandemic? I think this question is incomplete, but if I could understand the excerpt, it's related to how the implementation of COVID measure itself create social effects such as corruption. What is your opinion on that matter, Professor Linan? You are on mute, Professor. Okay.
Oop, I was on mute. No, I'm sorry. I thought you were addressing the question to Professor Verschuren. Could you repeat it a little?
Okay. So the question is, how about regulation COVID-19 in Indonesia that has many pro and contra? For example, human rights and social cultures and corruption of government in this pandemic.
Well, I would first of all hesitate to answer in the sense that I haven't been in Indonesia for a year. But I think the big problem is whether you regard this as a medical problem and not, for example, a civil liberties problem, in which case you follow what the medical doctors say you should do, although they have changed their mind from time to time. But the problem that was brought up was non-compliance. And the first speaker sort of showed the pictures from, I forget the location, of people digging graves, but I would think that's a somewhat unusual response in Indonesia. So I guess the question would be compliance, because when I read the newspapers, it sounds like everyone wants to do mudik anyway. So if the government, mudik being the sort of annual pilgrimage home at the end of Ramadan, and of course this would spread the disease all over Indonesia, and the government has declared that this is not going to happen as a legal matter. And I forget, but I believe last year there were 200,000 or 300,000 people who left Jakarta anyway to go home to Sumatra or wherever. So if you do rely on the medical stuff, I'm not sure that it's really a corruption problem. I think it's more people just say, oh, well, I'll go home anyway. So it may be, but I'm not sure you can convince them if indeed it's, to convince them to not go home, because there's an awful lot of leakage. That's a social problem. That's a pure compliance problem, but I don't think having people dig graves for COVID victims is going to be particularly effective.
Thank you very much, Professor. Now to the question directed to Ms. Julie Simba. So thank you very much for your presentation. I'm Shahrul from Faculty of Law. I have one question for you. When we discuss about impact of administration of justice, I found some confusion in my mind. When we compare the law enforcement in Indonesia and another country, maybe for some country making law a solution to overcome pandemic, but in reality, it's just a regulation, but it's very lacking of application. It's hard to provide public an understanding to comply with health protocols. How do you respond about this? Could you give us some suggestion or solution at least? Thank you.
Well, in Kenya, they have tried to do civic education to the public in order to ensure that these regulations are enforceable and the public can comply with them. As well as for enforcement, there are people who enforce the laws, like for some of the regulations like curfew, the police enforce them, and others, there are people who've been hired to enforce these laws, but mostly they're done by the police, and just like laws, regulations are also enforceable.
Okay, thank you very much. And another question, I think this is a lightning round questions addressed to all the speakers. Good afternoon. First of all, I would like to introduce myself. My name is Alisa Omir from Law Faculty of Hasanuddin University. I'm writing a thesis about protection of rights of marginal people during pandemic. And I want to ask to all speakers, what are the protection of rights in your country for marginal people during pandemics? Are there any exceptional steps for them? Thank you for your time. Well, just make it, don't make it fully explicit, Professor. She's gonna have a really easy time if you answer all the questions for the thesis. But I will start from Miss Julie and then goes forward back again. Yeah.
Okay, some of the regulations that have been brought about for the marginal people in Kenya have been for the old. There has been a cushion in budget that had been created for the old, whereby they're given a stipend to cushion them during this time.
Okay, thank you very much. Now to Professor Linan.
I would call out two examples, and one of them is good and one of them is not so good. The one that is good is it regards what we would call Native Americans, which are American Indians. And they still have really a non-written culture. And they're very concerned about preserving the health of their elders because they refer to them as their history. And there's been a special effort sort of paid to supplying the Indian tribes directly because they have a special problem with sort of the role of their elders, and elderly people are more subject to COVID. The second problem that I would bring up, which is not so positive, has to do with, let's say, people not wanting to comply or receive the vaccine. There is considerable suspicion in the population of African Americans, Black Americans, concerning government actions, so that, in the medical area, as a result of bad things that were done, let's say in the early 1900s, where people were subject to medical experiments without being told. And as a result, there's been a special effort to go through Black physicians and Black religious leaders to convince this part of the population to participate in the government immunization. because they're hesitant for historical reasons. So the special effort has involved what you might call African-American social leadership, but it's necessary to recognize that they're more hesitant to receive a government vaccine than, let's say, the Indians who want to get as much as they can because they're concerned about preserving their elders' health.
Okay, thank you very much, Professor. And now to Professor Fachri.
Yes, well, this question is not really directed at me, I think, but I saw a question also on population growth, and I think I could say something about that. And then I really have to leave because I have to chair another meeting which has already started, and I'm the chair, so I'm a little bit
Sure. I'm sorry for that.
anxious now to go. That's okay, but so of course, yeah, population growth is a big issue. It's a bit of a taboo to talk about it in a lot of countries, but it's clear that we are growing out of proportion if you look at what the Earth has to offer to us. But you also know from a lot of non-legal research that the best way to curb population growth is to educate women and children. That's really the most important. If you have good development programs in place, especially in developing countries, which focus on education of women and children, then population numbers drop. Yeah, hopefully, and at the moment, I think it's expected that after 2050 or 2060, this will happen automatically, more or less. But so that also again shows how interrelated everything is and how difficult a topic this is. You really have to address development issues together with environmental issues and health issues. They're all related. So I have to leave. So thank you very much for this this nice session, and hopefully see you later.
See you later, Professor. Thank you very much.
Bye-bye.
Bye-bye. Now, with the conclusion of response by Professor Fachri, I believe it's also a due time for us to conclude these panel sessions. First of all, we would like to apologize. I've seen throughout the session, some people raise hands. I assume they would like to have a question directly by the video call, but to our concern of time restrictions, we only entertain questions provided in the chat section. So apologies for that. But in any case, I would like to hand over my session to our MC. Ms. Fadilla, please.
Thank you so much, Mr. Riyad Febrian Anwar, for leading our second panel. And thank you so much for our speaker as well for the thoughtful presentations. It was very interesting. And it is very sad that it will also be our last session for today. I hope all of us have a great time and learn new things in this webinar, as it is a very precious opportunity that we could all hear presentations from speakers all around the world. Before we end this webinar, we would like to thank each one of our speakers and present them with a token of appreciation virtually. First, we would like to thank Mrs. Giselle Durana from the Philippines. Thank you so much for your presentations. It was a great time to have you in our webinar. Next, we would like to thank Dr. Bzhar A from Soran University, Kurdistan Region of Iraq. Dr. Bzhar A from Soran University, thank you very much for your presentations.
Bzhar, Giselle di sini.
Wait a moment. We will have some trouble to put this. Okay. Next, we will continue. We would like to thank Dr. Nirmala Pillay from Leeds Beckett University, United Kingdom. Thank you so much for your presentations. It was very nice to have you with us. And I would also thank my colleague back in Leeds University, Ms. Julie Kusimba from Arif Energy Holdings Limited, Kenya. Thank you so much for speaking on our webinar. Next, I would like to thank Prof. David Linan from University of South Carolina, the United States of America. Thank you so much for presenting on our event. It is very thoughtful that you are discussing and doing research on Indonesian topic So we hope that in further we could have more discussions. And last but not least, although he already left the Zoom room, we would like to thank Professor Jonathan Verschuren from Tilburg University, the Netherlands. And last but not least, the committee would also thank Dr. Iin Karita Sakharina for presenting the kick-off presentation so that we can have a snapshot of what is actually happened in Indonesian legal system and compare to the other countries. We also have a token of appreciations for our moderators for today. We would give a big highest of appreciations to Mr. Ahmad Fachri for leading the first panel sessions. And also I would like to thank Mr. Riyad Febrian Anwar for leading the second panel sessions. Thank you so much for your participations. Once again, on behalf of the committee, I would like to thank all of our distinguished speakers for delivering their presentations remarkably. And I would like to thank you all for your participations. For your informations, during our sessions, we have reached the participant as much as 380 participants. Thank you all for your participations. And before we end this webinar, now let us take a group picture. So for all the participants, please turn on your camera. I will take a screenshot and you can give your biggest smile. From screen 1, 1, 2, 3. To the next slide. 1, 2, 3. Third slide. 1, 2, 3. And last slide. 1, 2. Thank you very much. The certificate of attendance will be sent to your email, as you can see in the chat box. I hope we all can stay healthy, and we hope to see you again in the future. Thank you very much. Good afternoon, and maybe good morning for Professor David Linan back in the United States. Assalamualaikum warahmatullahi wabarakatuh.
Applause to all the